Hello and welcome. My name is Julia Chen. I'm the Activities Director at the Yale Club, and I'm so excited to see you all joining us for our virtual lecture series, where we bring in a live speaker to do a talk and a Q&A that you can participate in from the comfort of your homes. Today, we are excited to welcome Professor Mark Tushnet. A graduate of Yale Law School, he served as a law clerk to Justice Thurgood Marshall and specializes in constitutional law and theory, including comparative constitutional law, and is a professor today at Harvard Law School. His research includes studies examining skeptically the practice of judicial review in the United States and around the world. He also writes in the area of legal and particularly constitutional history, with works on the development of civil rights law in the United States and currently a long-term project on the history of the Supreme Court in the 1930s. In his new book, Taking Back the Constitution, Activist Judges and the Next Age of American Law, Professor Tushnet traces the ways constitutional thought has evolved, from the liberalism of the New Deal and the Great Society to the Reagan conservatism that has been dominant since the 1980s, and offers an argument for replacing judicial supremacy with popular constitutionalism, a move that would restore to the other branches of government a role in deciding constitutional questions. And without further ado, I'll turn it over to you, Professor.
Thank you so much. I'm happy to be able to give this talk on my forthcoming book. I'll actually have a copy here. You can, well, I'm not sure you can see the cover, but there it is. The official publication date is July 14th, I think, or 15th. It's available for pre-order now. What I'm going to do in this talk is outline most of the argument of the book. I don't think I'm going to talk much about popular constitutionalism, but in the opening remarks, but I'll be happy to discuss it in response to questions or comments from participants. And my talk is divided basically into three parts. First, sort of where we are or what the overall course of US constitutional development has been to get us to where we are now. Secondly, a sort of short summary of my interpretation of where we are now. And then third, a description of what I think are as three possible paths forward over the next decade or decades. In terms of the shape of constitutional law. Now, with respect to the first, I, in the book, rely on ideas developed by Professor Stephen Skowronek of the Yale Political Science Department, with whom some of you may have studied. I'm not going to go through the whole course of constitutional history, but starting in the 1930s, we've experienced sort of a flow of constitutional changes. And the periodization that I use says that roughly from 1937 through 1968, we experienced what I call the New Deal Great Society constitutional regime, associated with the ideas of Franklin Roosevelt and Lyndon Johnson and the expansive national government responsible for new areas of social welfare and so on. And then that regime sort of sputtered out for a variety of reasons, which I can talk about if people are interested in. And starting in 1968, we entered into a period that I describe as a sort of interregnum. The New Deal Great Society constitutional regime had ended, but nothing had really come to replace it. And then about after 12 years of this interregnum, we had the Reagan Revolution starting in 1980. Where there was a commitment to a smaller scale national government, although with expansive executive authority, particularly in the international domain. And the Supreme Court, Supreme Court in the New Deal Great Society period eventually started to and then articulated the principles of that regime. In the period starting in 1980 with some lag, the Supreme Court started to articulate the principles of the Reagan Revolution regime. And then just as the New Deal Great Society regime had sort of sputtered out, so too with the Reagan Revolution. Again, for a variety of reasons, it sort of lost its energy in the political branches around 2008 with the election of Barack Obama. And then we entered another, again, as I would describe it, interregnum, which has lasted until now. Now, there's one important feature of this description that I need to bring out because it plays a role in how we think about the contemporary Supreme Court. I talk in the book about an idea that I call judicial time. Professor Skowronek talks about political time. I talk about judicial time, the rhythm of change on the Supreme Court in particular. That judicial time is not aligned with political time. That is, when Franklin Roosevelt becomes president, the court doesn't immediately change. When Ronald Reagan becomes president, the court doesn't immediately change, although there the change was relatively rapid. And importantly, when these regimes peter out and the interregnums begin, the structures, the composition of the court that was installed under the regime when it was vigorous remains in place. And so you have a sort of holdover effect. And that's going to play an important part in describing one of the three paths that I think are opening up or may be opening up. That is, we will have in place for a while a Supreme Court shaped essentially by conservative Republicans over the past several generations. I begin the book, the preface, by sort of asking the question, when was the last time there was a Chief Justice who had been appointed by a Democratic president? And the answer is 1953. All the succeeding Chief Justices, including Earl Warren, were appointed by Republican presidents. And then when was the last time there was a majority on the Supreme Court of justices who had been appointed by Democratic presidents? And that's 1968. I may be 67, but 1968, I think. So more than 50 years since a majority of justices have been appointed by the Supreme Court. That's an indication by Democrats. That's an indication of sort of the way in which judicial time differs from political time. Because in the period from 54 to now, there have been a number of Democratic presidents, actually sort of almost equal numbers of Democrats and Republicans during that period. And yet the Supreme Court has become, I don't know, staffed by justices appointed by Republican presidents. Now I want to stress, to say justices are appointed by Republican presidents is not to say that either that the justices take their direction from whatever the Republican Party wants, or that the Republican Party has been unchanged during that period. And so there are justices like David Souter and Lewis Powell and Anthony Kennedy who were appointed by Republican presidents, but weren't in some sense reliably conservative. One of the features of the modern developments has been something we all experience in political life, the combination of polarization of the parties, so that Democrats and Republicans now basically don't overlap on any issues, at least at the leadership levels, and increasing ideological coherence within the parties. with Republicans having become more ideologically coherent than the Democrats, although Democrats are moving in that direction. Okay, so that's the sort of background picture. Now, second part of the talk is sort of where we are now. I'll just go through a few selected issues. I do more in the book. But let's take, for example, the issue of race, obviously something of central concern throughout US history and prominent today. What's the current status of the constitutional law of race in the United States? Well, it's primarily, doctrinally, it takes the form of saying the Constitution is colorblind, meaning in a case called Parents United, that it's unconstitutional for school districts to take race explicitly into account in attempting to achieve integrated schools, even in same doctrines applied in affirmative action cases. Sorry, where the court has upheld affirmative action, although it's worth noting it did so in a case now, I want to say 14 years ago, in which the majority said, look, we expect this to be over in 25 years. So we're sort of more than halfway to the end point of where the majority said affirmative action would be permissible. And it wouldn't be surprising if the court, with its current majority, sort of accelerated the schedule. So in contrast to the, say, Warren Court era, where the legal doctrine about race was, roughly speaking, favorable to and maybe even requiring governmental actions aimed at dismantling institutions of racism. The current doctrine is certainly of not of that sort, and may even be stand in the way of effective programs to do that. It's also worth noting, and I actually feel prescient in having done this, that I have a chapter in the book on, I frame it as sort of, what does the Constitution say about the Black Lives Matter movement? And the answer is that it doesn't say very much. It could, but the current interpretation doesn't give the Constitution much role with respect to the Black Lives Matter movement. But there's one area, again, prominent recently, in which the Supreme Court has articulated doctrines of two kinds that are impediments to the kinds of accomplishing through the courts the kinds of things associated now with Black Lives Matter. Most notable is something that's been in the newspapers over the past weeks, which is that the court has developed a doctrine called qualified immunity, which insulates police officers from liability, personal liability for misconduct, including constitutional violations, if they, under the circumstances, reasonably believed that what they were doing was constitutionally permissible. And then that's backed up by a doctrine associated with the Fourth Amendment law of searches and seizures that says police officers have a great deal of latitude in instituting and conducting various kinds of interactions with the citizenry. And so when you put those two things together, it means that the Supreme Court's doctrine about police interactions with the public is pretty lax or pretty supportive of police actions. Another area that was in the news several years ago, has been diminished to some extent recently, but will come back, is the law of free speech. I think most people are familiar with the way the court has developed a doctrine that finds restrictions on campaign finance, restrictions on campaign finance, unconstitutional restrictions on speech. In a case a couple of years ago, Justice Kagan used the term weaponization to describe what the court had done with the First Amendment. It had developed a doctrine, which I want to note has its merits, it's not indefensible, but it's developed a doctrine that makes it easy for, roughly speaking, the powerful to deploy the First Amendment against legislative efforts to regulate or respond to either their achievements in power or their ways of getting into power. A third area is more complicated. And this is an overlap. Condense here two things. One, what's the court done with respect to social movements? There's a strong strand in US sort of constitutional law that says the court's doctrines are typically responsive to important social movements. So Warren Court and the Civil Rights Movement, and a really interesting case, the contemporary court and the women's rights movement. It's an interesting case because when you look at it, nobody was appointed to the court other than Justice Ginsburg in order to advance the women's rights agenda or as part of the women's rights movement. And yet, well before Justice Ginsburg was appointed, the court had developed a doctrine that was increasingly favorable to the movement. Now, what about contemporary social movements? And here's where I divided it into two parts. The first is sort of think of social movements associated with the Republican Party. And so that's the gun rights movement and the sort of Christian right, the mobilized Christian right. The Heller decision, now 7-8 years old, was the court's response to the gun rights movement. You probably have read that the court has since stayed out of those issues, most recently within the past week. But the effect of the Heller decision was to sort of shift the political terrain or strengthen the position of gun rights advocates in political debates, making it even more difficult for legislatures to adopt regulations that, if they were adopted, might be found constitutional. What about the Christian right? Well, here, there are a couple of things that have happened. One is that the court has developed a doctrine basically requiring fairly vigorous accommodation of general laws to to people who object to complying with the laws on religious grounds. Part of that is done through an aggressive interpretation of a statute called the Religious Freedom Restoration Act. Part of it is done through a constitutional doctrine. Again, it doesn't mean that the Christian right wins everything. In the current circumstances, there's been a lot of litigation about the extent to which closing regulations can be applied to church services. The lower courts are sort of divided on that. The Supreme Court divided basically 5-4 in saying, look, the one that's before us looks, maybe it's okay, but things are changing so fast that we're not going to say anything definitive about it. And then the second aspect of the religious Christian right is that the court has become much more receptive to direct financial support to religiously affiliated institutions and such as church-related schools and in one case a church-related childcare operation. There's a case pending before the Supreme Court that I think is going to, my prediction is, will say, look, it's constitutionally okay for the government to give money directly from the tax coffers to schools affiliated with religious institutions. Something that would have been unthinkable to a generation or two ago. Finally, there are the culture wars issues where the picture is pretty complicated. One of the 4 years ago, I got into a lot of trouble for writing something, a blog post saying that basically progressives had won the culture wars, except with respect to abortion. And my example there was what then, 4 years ago, would have been called the gay rights movement. Now it's the LGBTQ movement. And what I find interesting is that with respect to tons of the stuff about gay rights, including gay marriage, there's no controversy anymore. There was the decision last week, which the most extreme conservatives said was a betrayal of conservative principles. But basically, the American people are fine with gay rights. The fights now are of two sorts. One about transgender people. Now, for somebody, I'm in my mid-70s, somebody who grew up in the 1950s, when gay bashing was, socially acceptable, it's astonishing that the fights are about transgender people, that the dial has moved so far that progressives have won everything up to transgender, and my guess is are likely to win those battles as well. And then there is the intersection between the gay rights issues and religious accommodation issues. And those were flagged in the non-discrimination decision last week. And I suspect that we'll see those fights continue. But again, it's worth noting that everybody agrees, I think, that those fights are going to be fairly narrow. That is, the vast range of the economy is going to be now covered by a law that says you can't discriminate on the basis of, that protects LGBTQ people from employment discrimination. The one exception here is abortion, where it seems to me, at least with the court as currently composed, Roe is basically doomed. The only question is, how is it going to be buried and when it's going to be buried? There's a case pending now that raises these questions, and I have no predictions about how that particular case will come out. But again, with the court as currently composed, the core holding of Roe, as the court has put it, is for all practical purposes not going to survive. Okay, so that's where we are now. I've talked for 25 minutes. Let me talk for a few more about where we might be going. there are, I think, three paths. The first is that the interregnum that we're now experiencing is going to continue. Gridlock in Congress. The effect of that is to give the court freedom to do what the justices want to do. That's an external observer's view of what happened. What does that mean? Well, I have this version in the book that I won't go into in detail here, but it means that if the interregnum continues, there'll be mostly conservative decisions, mostly pro-contemporary Republican Party positions, mostly pro-presidential positions, at least when the president is a Republican, and maybe some, if the interregnum takes the form of a Biden election, but Republicans controlling the Senate, you might find the court more sympathetic to ideas about controlling a Democratic president than they have been about controlling, I have to say, even Donald Trump. And here I want to note something that commentators write about. Well, there's always Chief Justice Roberts, who's an institutionalist. He wants to preserve the court's reputation as above politics, calling balls and strikes, and so on. My, again, sort of cynical take on this is something I call the 80% solution. 80% of the time, what Chief Justice Roberts is going to do is going to be consistent with the conservative pro-Republican stuff that I've just described. And then 20% of the time, he'll go the other way. The cynical view is for the purpose of establishing that at least he is not simply a political partisan. Okay, so in that world, again, we'll see a court siding pretty much with the Republicans, although not always. Second path is what I call a Trumpist consolidation. It's not entirely clear what that means because Trump is not an articulator of the values that underlie or animate Trumpism. We actually want to see or read what Senator Tom Cotton or Senator Josh Hawley say in order to capture the Trumpist, call it, ideology. To the extent that we can see something in it, already there's a certain kind of, I would describe it as nostalgic white nationalism that we're seeing in connection with the stuff about Confederate monuments and names of army bases. Another law professor says we see strong government at the borders and weak government inside the borders. That also seems sort of right to me. But as I say, we don't really know much about what a Trumpist regime would look like yet. And then the final path forward is progressive consolidation in all three branches, or at least progressive consolidation in the political branches, and then starting out with the Republicans, again, in my phrasing, controlling only the courts. And what's interesting about that is that if there's progressive consolidation in the political branches, the Democrats might be able to pass things, but they're going to have to get through the courts. And many of the things that are high on the Democratic policy agenda will raise plausible, I don't think probably correct, but plausible constitutional objections. The one that captures me most because of where I live is DC statehood. The official position of the Justice Department is that it's unconstitutional for Congress to admit DC as a state by statute. That goes back to the George W. Bush administration. You can imagine Congress doing DC statehood and then the Supreme Court saying, no, it's unconstitutional. Or the National Popular Vote Compact, a way of sort of by statute trying to work around the Electoral College. There are a variety of constitutional objections that could be raised against that. And you can go through what the Democrats presented as H.R. 1, their democracy agenda in 2019, and lots of this stuff could be constitutionally problematic. And then take the 80% solution. 80% of the time, the court will obstruct and thwart the Democratic initiatives, thereby frustrating the people who voted for the Democrats, thereby perhaps making it more likely that people will get fed up once again with government and then go back to some alternative. I just want to conclude with something that I've been involved in and happy to talk about. One response to this prospect of Supreme Court obstructionism of the Democratic agenda is something that's now going under the name of court reform. The proposed reforms take a variety of forms. The only one that has the prospect of, if enacted, has the prospect of being successful in the short run is expanding the court, adding new justices to the court, court packing, as it's known. I'm actually on record as being in favor of that. I think it's unlikely to happen, but, and this is what I'm going to finish on, there are some pretty good studies by political scientists, the most important one by a person at Emory called Tom Clark, who looked at not enacted statutes that affect the power of the Supreme Court, but proposals, threats to the Supreme Court. And he finds, I think pretty persuasively, that as it sort of regularly happens, the more it looks like a threat is a serious one, the more political traction it gets, the more likely it is that the court's going to respond by withdrawing from the positions that generated the threats in the first place. And so my position is, even if court reform or court packing isn't enacted, and even if it's not likely to be enacted, still it can be effective in changing the way the court as an institution behaves. Okay, so that's a shorthand for the book. And now I'm happy to address any kinds of questions that you might have.
Thank you so much, Professor. And yes, we will open for Q&A now. And while everyone thinks of your question, I'd love to hear a little bit, Professor. I think the takeaway is that the solution is a little unclear, but there's definitely flaws with our current system with the Supreme Court. How do you think that was just inherently part of how it was developed, that there were these flaws that were going to come about? Or has the American people changed in a way that are creating these problems now?
That's a really good question, and it's a complicated story. Part of it is the increasing acceptance among the American people of a very large role for the Supreme Court in our governing system. So 100 years ago, when the sort of what we now call the progressive movement with a capital P was vigorous, an important component of the progressive movement was a direct attack on the very idea of judicial review. In the century since then, that kind of attack has gone away. I'm probably the most prominent person in the legal academy who sort of thinks that, as a matter of principle, we should have a very scaled back kind of judicial review. But I understand that my position is a fringe position in the legal academy and among the American people. So the first thing is we've accepted a great deal of power. The idea that the court exercises a great deal of power. We sort of hope that they're constrained in their exercise of power in a variety of ways, but we're okay with their exercising power. Second, the mechanism by which the court was to be made accountable was through the appointment process. And that process has changed dramatically over, say, the past half century. My take on it is that the process of appointing justices has always been a political process, meaning that it mirrored the kind of politics that occurred in the political branches. So there was a long period when politics in the political branches involved patronage and horse trading across party lines, and you got justices who were appointed by horse trading and patronage. What has changed, and again, political scientists are pretty clear on this over the past 20 years, is the underlying political process has become hyper-polarized, as I referred to earlier, which means that the appointment process has become hyper-polarized. And that has contributed to the the malfunctioning of the system overall.
Thank you. And we have a question in the chat that's asking, if this reform policy of expanding the Supreme Court were to be, how would this be passed, given that it would be giving more power to the Democrats?
Yeah, so, right. I want to say, I started by saying it's unlikely. I can imagine a scenario in which Democrats control the Senate. That's a condition. First of all, they have to get control of the Senate. Clear that in the short run, they're not going to get enough to overcome the filibuster rules. So first of all, they'd have to say, well, we're going to modify the filibuster rules in some way. I have the thought of saying, just as they've modified the filibuster rules for budget-related legislation, they could modify the rules for democracy-related legislation. And they would have to get their heads around, the first part is easy, adding, my version is a couple of justices to the Supreme Court. The political rhetoric about that is pretty straightforward. The Democrats take the line. I'm not endorsing this version of just articulating what people say. Mitch McConnell stole the seat for Neil Gorsuch. And we have to get it back. Now, we can't kick him off the court. So in order to get the seat back, we have to add two people, one to offset Gorsuch and one to get the Merrick Garland seat. So that part's pretty straightforward. What I pick up on when I do this is, but people say, but wait a minute, if we do this now, the Republicans are just going to do it again when they get a chance. And so the Democrats have to get their heads around that prospect. My response is, look, you've got starting, if on the assumption that you control the House, the Senate, and presidency in 2021, if you enact the statute in 2021, it's there for 4 years. Because the president will be a Democrat who will veto, even if the Republicans take back both the House and the Senate in 2023, President Biden would veto a tit-for-tat court expansion. And if the story about Supreme Court obstructionism leading to gridlock and disillusionment with the Democratic Party is right, then you need to get rid of them so that you can re-elect or elect another Democrat in 2024. Now, I don't think the Democrats are going to get to that position, but that's the line of development that would have to occur.
Great, thank you. And on a little bit of a tangent, I wanted to ask you a little bit about your book writing process, because I've always been curious for something like this, where there's history, but it's also about what's currently happening in order to offer recommendations. When do you decide that you're done? When do you decide that this is the endpoint you'll take with your book? And have you, since things have developed since, have you wanted to include more things in your book that you didn't get the chance to?
So this is in some ways, the third book of this sort that I've written, and it's always a problem because the book goes into production and it's taken out of my hands 9 or 10 months before it appears, and until the pandemic, the Supreme Court just keeps churning out decisions, and during that 9 or 10 month period, important things can happen. I just have to swallow and say, look, this is the story as of basically a year ago when I finished the book. Some of the things I think hold up. Today I would do more about the 80% solution than I do in the book, because we've seen things like the employment non-discrimination decision and Chief Justice Roberts' reluctance in the pandemic church closure cases. But I'm stuck. I don't think what has happened will undermines anything that's in the book. The one thing that I am sort of nervous about in terms of the book, I think is extremely unlikely. It's not beyond the bounds of possibility for a majority of the court in the pending abortion case, a majority of the court, meaning Chief Justice Roberts, to say, we reaffirm the core holding of Roe and Wade. I don't think that's at all likely. But if they do that, then what I said about Roe being doomed just is no longer valid.
And as a pretty good follow-up to that, Laura is asking, why did the Supreme Court go in such different directions on gay rights versus abortion?
So there, I go back to the social movement story. It's not or social transformation story, really. The story everybody tells, it's not mine uniquely, but the story everybody tells about gay rights is a cultural transformation that is captured by will and grace. And so the will and grace story about the Supreme Court is that the justices are participants in a culture that over their lifetimes has become committed to what, again, a generation ago would have been called gay rights. And they have become comfortable with that. So there's this famous incident from 1986 when the court upheld the constitutionality of homosexual sodomy laws, making homosexual sodomy a criminal offense. The deciding vote was cast by Lewis Powell, who said to his law clerks and his colleagues, he'd never known a gay person. Harry Blackman went back to his chambers and told his law clerks, Lewis Powell doesn't know who he knows. And in fact, one of his law clerks, Powell's law clerks at the time, was gay. I'm pretty sure that every one of the justices has had and knows he or she has had gay law clerks, more than one, over the course of their careers. And it's just not a thing for them. Now, it not being a thing doesn't mean they think that as a constitutional matter, the LGBTQ agenda is constitutionally rooted, but they're not going to get excited about it. Okay, so there's that cultural transformation. On abortion, the social tensions have been persistent since 1973 when Roe was decided. And so there's there's a vigorous pro-choice movement, there's a vigorous pro-life movement, and the courts, in that sense, as I said before, sort of free to go where the justices think they ought to go. And okay, so that, I think that's the story about the differences between the two.
Right. And another question is asking, do you think that this two-party system that our forefathers warned us against is the reason for our current problems with the system?
Mostly this gets into political science more than law, and so I'm a little reluctant to say much about it. It's pretty clear that the current hyperpolarized party system is a problem. And it may be, I'm less sure about this, that the current system sort of emerged organically as a result of constitutional arrangements. The reason I'm not sure about that is that this hyperpolarization is recent. The constitutional structures have been the same. They supported patronage and so on systems earlier. They now support hyperpolarization. So, and its effects on the courts. As people talk about sort of getting out of the current situation, there is interest in political reforms that would perhaps transform the party system. Obviously, changing the campaign finance system might do that. I think that's very difficult to do, but and that does fall in the domain of constitutional law. People talk about the national popular vote for the president, or various forms of changing. We now have what's called first past the post. The plurality winner becomes the incumbent, changing away from that to other systems that are either sort of proportional, or there's the national, it's called a transferable vote system, where you rank your people. And so sometimes the person gets elected who's sort of everybody's second choice, and that's sort of thought to be a moderating effect. But those are mostly political things that I'm not really an expert on.
Great. So I don't think we have any other questions. So as a last question, if we could ask you, what can, if anything, the average person do in these days? What should we be doing?
So that's easy. It's participate in politics and learn about, for me, and now speaking in my guise as a constitutional lawyer, as you participate in politics, people are, of course, most focused on immediate policy issues. The Green New Deal, the policy response to the pandemic, and that's, of course, sensible. But I think as part of participating in politics, it's important at least to get familiar with the way in which our constitutional structures contribute to some of the current problems of policy making.
Great, thank you so much. Well, I've learned a lot, and I'll go out and learn more, but thank you so much for taking the time to share all this with us today.
You're welcome.
And thank you everybody for attending. We hope you enjoyed. We have lots more content coming up, so be sure to check out the online calendar. And I did post a link in the chat if you're interested in pre-ordering the book through the site called bookshop.org, which supports local bookshops. But otherwise, we hope to see you at another event soon. Stay safe and stay connected. We'll see you next time.